Welcome to today's online panel discussion on mergers and workers, labor market aspects of the proposed U.S. merger guidelines. I'm Carey, Director of the Penn Program on Regulation at the University of Pennsylvania. The Penn Program on Regulation is very pleased to have organized today's webinar and to co-sponsor it with our colleagues at the Center for Technology, Innovation, and Competition. We're excited to be hosting this very timely discussion on the 2023 draft merger guidelines, which the U.S. Department of Justice and Federal Trade Commission issued earlier this summer for public comment. And the comment period, I should note, ends on September 18th. The discussion today will focus specifically on provisions in the proposed merger guidelines that would address anti-competitive effects of mergers on labor markets. And to help us explore the implications of these new provisions, we're joined today by a panel that includes two high-ranking economists from both U.S. antitrust agencies, the DOJ and the FTC, colleagues of ours who were grateful for their public service. And joining them will be leading legal scholars who specialize in antitrust law and policy. Let me just highlight that today's discussion is slated to run for about 75 minutes. We will aim to end promptly at 1:15 Eastern Time. Before we get underway, I do want to encourage members of the audience to begin to think about what kind of questions you have for the panel members, and to know that you can become part of the discussion by submitting any questions you may have for our panel members at any point in time during the webinar by using the Q&A button at the bottom of your Zoom screen. And we'll do our best to get to as many of your questions as time allows. Also, please note that this webinar is being recorded and the video will be posted subsequently to the Penn Program on Regulation's YouTube channel. You can find the link to that channel by visiting our website, www.pennreg.org. And now I'm honored, very honored, to introduce our moderator for today's discussion, my distinguished colleague, Herbert Hovenkamp, who is a world-renowned scholar of antitrust law and policy, the James Dinan University professor here at the University of Pennsylvania, where he has faculty appointments at both the law school and the Wharton School. He's the author of over 150 articles and book chapters and more than a dozen books, including the landmark 21-volume treatise, Antitrust Law, which is the most cited antitrust authority in the country. Professor Hovenkamp is also an appointed fellow at the American Academy of Arts and Sciences, and in 2008, he earned the John Sherman Award from the U.S. Department of Justice for his lifetime contributions to antitrust law. I'm delighted to turn the webinar over now to Professor Hovenkamp, who will introduce our panel members and get the discussion going and moderate it. Herb?
Carey, thank you very much. Early in his term, President Biden issued an executive order on American competitiveness. And of the many things he covered in that order was an order to the agencies to redraft merger guidelines. The last set of guidelines had been put forward in 2010. Previous guidelines have also discussed the impact of mergers on labor, but this new draft is much, much more elaborate than those previous guidelines were and take some different approaches. So today we're going to focus on one of the 13 provisions called guidelines within the proposed draft 2023 guidelines. Incidentally, the guidelines are currently in draft form, subject to revision. And if you want to make a proposal to the agencies, there's still time to do that, to make proposals for how you think they should be changed. As Carey said, we've got 4 extremely distinguished panelists. Avi Nevo is the George and Lydia Weiss University, or PIC professor in economics and at the Wharton School. He's a leading scholar in empirical industrial organization and econometrics. He's currently on leave, serving as director of the Bureau of Economics at the Federal Trade Commission, and he's been quite involved in both in drafting and in promoting the 2023 draft guidelines. Ioana Marinescu, also an economist, is an associate professor of social policy and practice and a research fellow at the National Bureau of Economic Research. Her principal interest is labor economics. She's been particularly helpful to me in the last few years as I've struggled my own way through the relationship between antitrust and labor. She is also on leave, serving as principal economist in the antitrust division, and she's also been involved in the merger guidelines project. I think, incidentally, that University of Pennsylvania should be particularly proud of the fact that these 2 very high-ranking economists, one representing each division, are both our own, both faculty members at the University of Pennsylvania. Commenting, we have Sanjukta Paul, who's professor of law at the University of Michigan. Sanjukta is a prolific writer in the fields of labor law and antitrust. She is currently working on a book, Solidarity in the Shadow of Antitrust, Labor and the Legal Idea of Competition. And then we have Gus Hurwitz, who's senior fellow and academic director at the Carey Law Center for Technology, Innovation, and Competition, or CTIC. He's also the director of the Law and Economics program at the International Center for Law and Economics. He's also a prolific writer in the field of antitrust, focusing particularly on digital markets. So the way we're going to proceed is I've asked, first of all, our 2 agency representatives, Aviv and Ioana, each to speak in that sequence for 7 or 8 minutes or so, giving their own perspectives and what they think they want to say about the guideline 11 of the proposed guidelines, which covers mergers involving suppliers, including labor. At that point, I'll turn it over to Sanjukta, who will comment, and then to Gus, who will comment again. After that, I'll have some questions, and following that, we will have questions from the audience, and we will end promptly at 1:15. So with that, Aviv, it's yours.
All right. Thank you, Herb, for that kind introduction, and thank you, Carey, and the Penn Center on Regulation for putting this event together and inviting me to speak at it. Before I start, I need to provide the usual disclaimer. The views I'm about to express are my own and do not necessarily represent those of the Commission or any divisional commissioner. So as you know, and as was mentioned a couple of times today, the FTC and DOJ issued draft merger guidelines on July 19th. We are now in the comment public period, which will go on until September 18th, so this coming Monday. As Herb mentioned, if you're at all inclined, please submit your comments. We are really looking for feedback and eager to look at them. I haven't checked in the last few days, but last time I checked, there were already several thousand comments. So we're glad for all the interest and are happy to get even more. So please add your comments if you're inclined to do so. So the workshop today is part of our effort to get feedback. The focus, as mentioned, is going to be on Guideline 11, the guideline that discusses mergers and buyer's market, including labor market. At a high level, this guideline says that the basic ideas, methods, and tools that the agencies use in product markets will also be applied and used in input/labor markets. This in itself is not new. I mean, the 2010 guidelines, the 2010 horizontal merger guidelines, had a clear provision, Section 12, I believe it was, that pretty much said the same thing. We are obviously kind of elaborating more on the labor side, but also because these guidelines rely on a slightly different set of tools that are present in the other guidelines, not guideline 11, I thought it might make sense for me in ways of introduction just to say a few words about them just in terms of ground setting before we zoom in into guideline 11. Specifically, I'm going to focus on the first 2 or 3 guidelines that really talk about horizontal mergers. So an organizing theme of the draft guidelines is that mergers should not substantially lessen competition. This is particularly stressed in guideline 2, but holds throughout the document. Indeed, I hope that in the revisions, we'll actually be able to clarify this relationship. The logic is that any merger that lessens competition deprives consumers, or more generally trading partners, including sellers of inputs or workers, of the benefit of this competition. What are the benefits? Lower prices, more choices, higher quality, more innovation for consumers, and if you want to focus on workers, higher wages and better employment terms. Okay, so lessening competition deprives consumers/workers of these benefits. We say these a couple of times. We say it in guideline 2. We say it in guideline 11. Specifically, we probably, again, need to be a little bit more clear in stating this kind of coherently throughout the document. Now, those that are familiar with the 2010 horizontal merger guidelines will note that the draft guidelines changed the language a bit. Okay, in 2010, there was, at least in the introduction, a mention that the animating principle, the animating theme of the guidelines is market power. While I talked about a lessening of competition, some people have tried to read into this as a change in focus. I personally do not see it that way. Indeed, when we talk about the tools and methods and metrics that we're going to use to measure lessening of competition, they are the standard tools, the same tools that were discussed in 2010. So in some sense, there really isn't much of a difference here, maybe just a change in the language. So you might ask, if there's no difference, why change the language? Why not stick with what was used before? So I think a couple of reasons, at least kind of from my perspective. First, a lessening of competition directly connects with the language of the statute. We're not going to talk much about it today, but another theme that's present in this draft is trying to introduce kind of a tighter connection with some of the case law and the existing law. So that was a benefit of sticking with the lessening of competition, which was the original language of Section 7. The other perspective that, from my perspective as an economist, is quite important is that by focusing on a lessening of competition also helps us in discussing the evidence. So again, we're not going to go much into this, but when we discuss the evidence in the appendix, we really talk about the fact that there's a lot of evidence that can be used to shed light into the investigation that the agencies conduct. And that there's a lot of so-called intermediate evidence. What I mean by that is, while the ultimate goal is understanding prices, quantity, quality, we're not always in a position to fully go and either simulate or try to predict what the effect of the merger will be on these on the ultimate outcome. Right? And there's a lot of intermediate evidence that allows us to directly speak to the lessening of competition. And we think that evidence is quite important, especially in those cases where we're not, where we can't, for a variety of reasons, to map out the full impact on outcomes. And we think that is much easier to explain and use when the focus is on a lessening of competition. So anyway, that's kind of the reasons for the change. The appendix, as I said, discusses data, methods, and tools used to measure listing competition. It includes all the tools and the models that were in 2010, and it has in a few additional as well. So if you ask, okay, you didn't define what it is, but what are you actually going to do? You can see that what we're going to do is essentially what 2010 did. Okay, let me say one more, make one more point about one of the guidelines that's going to be quite important as we talk about guideline 11, and that's the first guideline. This first guideline is so-called the structural presumption. It, like previous guidelines, including the 2010 horizontal merger guidelines, lays out concentration thresholds, which a merger that, if exceeded, a merger is presumed anti-competitive. It captures an intuitive idea, right? A merger that it's likely to lead to lessening of competition, or I can ask yourself, what merger is more likely to lead to lessening of competition, a 10-9 or a 3-2? Well, probably the latter. And that's what this is trying to capture. Now, I should note that this is a rebuttable presumption, a point we need to be a little bit clearer about. And how is it rebuttable? It's rebuttable with economic modeling and evidence that the increase of concentration is not indicative of an anti-competitive effect. Again, we need to clarify that, but that, to us, that's the point here. And the point that it's rebuttable is, again, because the structure is supposed to be indicative of the ultimate outcomes that we would care about. Now, some commentators have noted that we do not explain why we care about structure, and we should be clear about that. And together with the change in the language for market power that I talked about earlier, see this as caring about structure for structure's sake. Okay. The same folks also noted that the language in Guideline 11 is a little bit different. Maybe we'll get to that. I should point out that I don't see it that way. I don't see Guideline 1 as a fundamental change. And yes, maybe we need to change the drafting of the language to make clear that that's the case. But to the extent that there's any issue here, I see it as a drafting issue. Ultimately, we care about structure for exactly the same reason that I've stated before, and that are stated, I think, maybe more clearly in Guideline 11. Guideline 2 and 3 lay out the standard methods and tools of unilateral and coordinated effects. In most cases, I imagine that these guidelines, especially in Guidelines 2, will be used together with Guideline 1. However, I can see in cases where market definition is difficult, and it's quite often the case when you try to go to kind of more modern markets, more complex market, we could go with just Guideline 1 and define a very broad market just to meet the legal requirement and not worry as much about the structure. So that's kind of my view on the overall themes in the guidelines. And let me turn it over to Anna, who's going to talk specifically in more detail about Guideline 11.
Hello, everybody, and thanks very much, Aviv, for setting the stage. So, if we look at Guideline 11, as Aviv just mentioned, it's very much an application and elaboration of everything that came before to labor markets and to buyer markets more generally. So, of course, the fundamental principle is that mergers can decrease the competition for labor and increase the risk of employer collusion. So those are major concerns here. So importantly, this is not new as an idea. In fact, since 1982, the merger guidelines have mentioned competition among buyers as a concern when agencies are looking at mergers. And so we note that employers are, of course, buyers of labor services. And so we are just clarifying that this long-standing concern from agencies applies to the realm of labor markets. And to note, monopsony power is the mirror of monopoly power. So, if you do an analysis in product markets, you're going to look at competition among sellers to attract buyers, consumers. And if you look at labor markets, you're looking at competition among employers buyers this time. So buyers or employers are competing to attract workers who are sellers here. So workers are sellers of labor services. And so everything that we usually do to do an antitrust analysis of product markets applies here, but you have to think about competition among employers to attract workers. Again, competition among buyers to attract sellers. And so it's also worth noting that the DOJ has successfully won a merger challenge in the Penguin case just about a year ago, where for the first time a merger was blocked on account of monopsony concerns. And this merger was won under the 2010 horizontal merger guidelines. So these guidelines, these draft guidelines we're talking about today, are part of the evolution of agencies enforcement in the continuation of what we had right before. So the draft guidelines, I want to make a few key points about guideline 11 specifically, which is the guideline about labor and also buyers in general, so input markets in general. So with respect to labor, first of all, this guidelines is seeking to reflect economic learning, showing that labor markets have some specific characteristics that can make them especially narrow in some cases, including we have to be concerned about switching costs between jobs. We have to be concerned about search frictions. And there's been a growing economics literature, including my own work, looking at how competition works in the labor market. And secondly, this guideline clarifies that agencies will evaluate these impacts of merger on labor as a standalone basis to challenge a transaction. So the labor market concerns are enough by themselves to challenge a transaction. Then, of course, these concerns that we can establish through any of the guidelines before, it could be, as we mentioned, typical frameworks would be guideline 1 or 2. Not there's others, but those would be often used with concentration or unilateral effects. Then we can apply them, this or many other guidelines to labor. But this being said, that's the prima facie case. And then there's always an opportunity for parties to have a rebuttal. So they want to say, our merger is okay. And so we have a section on rebuttal that says that the parties can present evidence that the merger doesn't in fact harm competition. And importantly, if we're looking at labor markets, this evidence has to pertain to labor markets, because where the agencies will have claim in their prima facie case that this merger presents, may substantially lessen competition in the labor market. Therefore, the rebuttal must be able to prove that, in fact, the merger does not threaten to lessen competition in the labor market, importantly, because this is the market that we are discussing. And finally, in terms of how we are going to go about demonstrating the potential harms or the absence of harms of a merger is by using a set of tools. A lot of those details are exposed in the appendix. And this includes the extensive set of tools that were already there in the 2010 horizontal merger guidelines. And you will note in the appendix that there is a clear parallel between input or labor markets and output markets. So we talk about being concerned about, for example, price increases or wage increases, about product quality or job quality, etc. So all of this is very much symmetric, and the appendix again includes a wide set of tools, including all of those that are familiar, to analyze competition in labor markets. So this concludes my set of initial remarks, and I really look forward to the discussion. Thanks.
Thank you. Sanjukta, you're next.
Hi, everyone. Thanks for having me on this panel. Hopefully folks can hear me. I'll try to speak up. Okay, so I'll I'm going to be brief in my comments, and I just want to make, I think, a few points. And I want to start by going back, I think, a bit and pointing us back to the statutory basis for this activity by the agencies, both in terms of the statutory text, but actually also just for a moment, to the origins of the statute itself. So as you know, most of you know, the context of the Clayton Act of 1914 really came out of efforts to strengthen antitrust enforcement, and really was the culmination of several legislative attempts and efforts that seemed to respond to Supreme Court cases relating to merger regulation. So when there would be, so for example, the legislative effort sort of tamped down after the Northern Securities case, where the Supreme Court took action against a merger. But when there would be a case, and then when there would be a case that was seen as sort of insufficiently making good on the promise of the Sherman Act, which happened frequently, this would tend to prompt legislative activity again. So really, I think you have to understand it as a culmination of these legislative efforts. And it occurred most immediately in the wake of the Standard Oil decision, which was seen by many in Congress as not going far enough. And importantly, this effort and desire on the part of legislators to strengthen antitrust enforcement and to shore up the Sherman Act really had as its target what at the time was called the trust, which could be a single firm, it could be practices between firms, but the target was quite clearly concentrated economic power, and with a goal of preserving business rivalry and dispersed economic decision-making. It's quite clear, I think, from the record. And I think to mention, I think, a couple of things here. The most immediate precursor of the Clayton bill was the Lafayette-Lenroot bill, according to Earl Clintner, who is very helpful in the legislative history here. And populists like Lafayette and populists and progressives like Lafayette and Brandeis were critical in the passage of the Clayton Act. And it was, just very clear that the goal here was concentrated economic power, the target. I also want to briefly mention that the Clayton Act legislative effort was twinned with the FTC Act in the beginning. Of course, both acts are passed in 1914. And if you look at the legislative discussion, the way that legislators seem to be thinking about this was that the Clayton Act is going to shore up merger regulation, and it's going to target certain practices, right? We're not talking about that today, but I'm mentioning this in the context of the agency's power and role here. So the Clayton Act shores up merger regulation, but also targets certain practices, for instance, tying contracts, other practices that had emerged in the preceding sort of 15 years or so, perceived, whatever your views about it, perceived as tools that the trusts or dominant firms used to cement their position and to preclude competition from new entrants, or for existing market participants who might become more viable. But at the same time, Congress recognized that just as these additional practices have sort of cropped up since the time of the Sherman Act, there will be more practices that we cannot currently foresee. And that's why we need a federal trade commission to investigate, to constantly increase its knowledge and to be empowered to pass rules to target new practices that appear. So this is an express twinning of the two legislative efforts that we see, I think. I'm obviously stating it in a fairly conclusory way right now, but I think that that's the case. And so I think that this extends to some extent, I think, to our understanding, or should extend to our understanding of merger regulation as well, in terms of really understanding the legislative intent to empower the Federal Trade Commission to use its accumulated knowledge, I think, as it's now doing with specific features of labor markets, as Ioana talked about, and as Guideline 11 evidences. So I just wanted to give a little bit of that context. As well, of course, as you all know, the statutory text that we're looking at here refers to mergers or acquisitions that tend substantially to lessen competition or tend to create monopoly. And I think we have to note right away, this doesn't say anything about efficiency. It doesn't say anything about even sort of genuine operational efficiency, much less does it say anything about lower costs or lower prices that may be achieved, importantly, and I'll come back to this point, through causal mechanisms other than true technical efficiencies, and that may, in fact, be at odds with the goals of the antitrust laws. So we can come back to that. So really briefly then, on the specific topic of today, Guideline 11 and the labor aspects of these guidelines. I think that it's very interesting that something that stood out to me, in addition to the points that have already been made, these observations of accumulated economic knowledge, that labor markets are often quite narrow, there are higher than usual switching costs, demand tends to often be very specific, and that this exacerbates competition concerns. The point in the guideline that loss of competition among buyers and specifically employers, buyers of labor, is not to be offset by purported benefits in a separate downstream market. I just want to point out, just conceptually, that I think we talk about this in terms of whether cross-market balancing is allowed, but I think that there's an even more fundamental point that I think is being made here, right? Because I think that this is challenging at least in the context of labor markets, but therefore it, I think, tees up this larger issue. It's, I think, starting to challenge the whole method, the whole assumption that we should undertake a trade-off between operational efficiency read in terms of prices and competition, right? And this is the debate in a way that is occurring, I think, around these merger guidelines. And I think I read that sentence, I'm curious what other people think, as actually having sort of deeper implications for that larger debate beyond the question of sort of cross-market balancing, which sounds like a narrower concern. Okay, so finally, I want to make the one other point that I referred to up top, which is that I think that the focus on labor markets highlights another important issue that sort of can lurk within claims of efficiency and lower prices. Certainly, I think that consumer prices were a concern of legislators here and are appropriate to be part of the inquiry. But there is an important issue that we have to confront, regardless of what our ultimate views on this are. And I think that that issue is that sometimes low prices result, so first of all, when low prices are lower costs are passed down to consumers, which obviously they're not always, but putting that issue aside for the moment, let's assume that we have a situation with lower costs that does result in ultimate, lower end prices. We have to confront the possibility that sometimes, not always, that is the result of lower wages, that those lower costs consist in lower wages rather than true technical efficiencies. And now we should, there's much more to say here about what the causal sort of pathway is to get to that point. But at least sometimes, I mean, I'm making very modest claims here, I think, at least sometimes those lower wages are the result of superior bargaining power that permissive merger policy actually increases, right? And permits, and is not the result of any sort of true technical efficiency. And I think that this points to a bigger issue that probably at least all the panelists here, or most of the panelists, have probably heard me say before, so I'm sorry that it's repetitive, but I don't think we've sufficiently integrated it into our thinking, which is that there is a distinction between lower prices resulting from true technical efficiencies and lower prices that may result from one firm that being in a dominant position such that it's able to negotiate lower costs either by exerting buyer power down its supply chain, which is, I think, not economically beneficial. It's not good for workers in terms of the wages that suppresses, whether it's workers here in the U.S. or workers down, through global supply chains. But also, I think, can harm the firms in that supply chain and is not good for economic resiliency, leads to, extremely sort of, what's the word? The opposite of resilient, very thin supply chains. We saw the impact of that during the pandemic. And I just think that in our antitrust thinking, we need to start distinguishing between true technical efficiencies and lower costs obtained by other means. And a starting point, and in doing that, we happen to be supported, right, by this statutory text and legislative background that suggests a concern that actually doesn't name efficiency at all. So I'm not saying we shouldn't at some point consider it, but I think we need to be much, much more careful about how we're deploying efficiency claims and how we are understanding the role of lower consumer prices in the overall analysis. And then actually, I'm going to say one more small thing, which is that from in terms of labor and mergers, I won't elaborate on this, but from a kind of macro perspective, which we often also don't take in antitrust, right? But from a macro perspective, I think that there are multiple people in the sort of law and finance world who have pointed out that a permissive merger policy, regardless of its impact on particular firms, we tend to talk about particular firms and markets in antitrust, and that's appropriate. But it's important to also bring in the perspective that a permissive merger policy overall, from a macro perspective, tends to result in a net transfer from the productive sector to the financial sector, and that is overall not good for labor. So I wanted to put that in as well.
Thank you. Okay, Gus?
Okay. Welcome, everybody. Thank you so much for having me as part of this discussion. Thank you, Herb and Carey in particular, and my co-panelists. I should start by noting, Herb mentioned, in addition to my UPenn affiliation, I work with the International Center for Law and Economics, and ICLE is working on comments that we'll be submitting in response to the proposed guidelines. And for those who know my work and the work of ICLE, unsurprisingly, they will be critical of them, but I want to start and emphasize that this isn't for the sake of being critical. I am, and my colleagues at ICLE are incredible believers in the importance of strong antitrust law and the merger guidelines. And our focus is really making sure that the guidelines are persuasive to a broad audience, and in particular to the judiciary. The importance that the 82 guidelines have had in shaping antitrust law can't be overstated, and that largely stemmed from their persuasive power. I hope to make 3 points in my comments, and perhaps to finish up with a couple of smaller points if I am sufficiently efficient. in my presentation. IO joke, apologies. So my starting point is taking a step back and to look at the literature on labor monopsony in general. This has been an incredibly important and I'll say persuasive literature. It's raised a lot of important questions that has, I think, everyone in antitrust thinking about the role of labor in antitrust law. But it is also still a new literature, and I worry that it's premature to incorporate it into the guidelines. In particular, for instance, there are recent papers coming out just in the last year or so that start to drill down into labor concentration at the local versus the national level and look at other sources of data and suggest that the pervasive effects of increasing labor concentration over the last decades isn't necessarily uniform in all sectors or depending on how you divvy up the data. My general thought on what to do with this is bring cases, litigate, let courts and Congress set the initial direction of antitrust law if there are changes that are needed in how we think broadly about mergers in particular, then we can incorporate that into the guidelines. My second point is it's unclear to me what the market is for antitrust purposes, especially where input and output sides of the market might be intertwined. So one example that we can think about here is the Penguin case, which certainly had labor effects. But if my recollection of it is correct, the court also discussed concerns that that would allow a reduction in choices that consumers had and the overall quantity of output. So labor market concerns on the publisher side vis-a-vis authors, but consumer side effects. And more generally, we can consider any number of hypotheticals, which frankly aren't all that hypothetical right now, where there are sudden disruptive innovations that could allow for a dramatic reduction in labor needs by firms. And this is what the writer's strike is about. This is what the potential UAW strike is about. These are important society-wide concerns that we're debating at the highest levels of government right now. I wonder how a merger that allows an employer to increase its output while significantly reducing its workforce would be treated under the guidelines. Under that sort of case, a firm would certainly have increased, and I'm quoting now from the proposed Guideline 11, would have increased power to cut or freeze wages, exercise increased leverage in negotiations with workers, or generally degrade benefits and working conditions. They're possibly thinking about this could be part of the merger, laying off a significant portion of their workforce. Of course, they would have those powers over the employees. My general thought here is that these are important generational society-wide level policy discussions, and it seems unusual to treat them as an antitrust issue foremost. Now, that's not to say that we shouldn't be thinking about these in merger analysis, but as we have already heard, these issues are already incorporated into the guidelines going back to the 82 guidelines. So I wonder what work Guideline 11 might be doing here. More generally, I worry that the input and output sides of the market can't be separated as cleanly as the guidelines want to do, especially when it comes to efficiencies. Ordinarily, the benefits of efficiencies are going to be split between consumers and producers, depending on relative elasticities of supply and demand. Hard empirical question exactly how that plays out, but you would expect there to be some split there. And the same is true of improvements in the marginal productivity of labor. If labor efficiency increases, marginal costs at the original level of output go down, allowing the firm to increase output back to the original marginal cost. And this is going to lead to some revenues, rents, however you're going to think about them, that will be split between consumers, the firm, and labor. I don't see how we can treat these as separate markets cleanly if there is some interrelation between how these benefits are being produced and divvied up across the various stakeholders in the supply chain. A couple of final quick thoughts. First, I know the guidelines expressly don't discuss remedies. There are separate remedies guidelines, but I wonder what the remedies are for labor market concerns in mergers. And I think that it's really important to think about this when we're thinking about what the legal approach is going to be. I expect that we would see some amount of conduct remedy negotiated, and also fix it first sort of remedies, firms making long-term labor commitments, for instance, as part of the merger. And those are both remedies that the current agency leadership is skeptical of. So I think that we need to have some understanding of the role of remedies in these cases. I also wonder about the role of labor regulation generally as a better approach, or whether labor regulation generally is, I should just say, a complementary or a substitute approach to these concerns. This again dovetails in with this idea that these are important national social issues that we are debating. And I think it is important to understand how the antitrust side relates to these broader policy discussions. I'm at 8 minutes. I will finish up there.
Thank you very much. Okay, I've got a few questions. And for the first one, I want to share the screen. I have one and only one slide. Right there. Can you see it? Good. Okay. Statements like this can be found in a lot of sources. They're fairly mainstream. I picked this one because this is a very prominent, highly respected piece from the recent past, and it's pro-enforcement. It's by people who believe that there's significantly more market power in the economy today than there was in the past. I just want to go through it a second, and I think this is mainly in reference to what Aviv and Sanjukta have been saying about, which is how does concentration and performance relate? Now, Aviv has assured us that there's, I think, if I'm reading him correctly, that there are going to be some changes made in Guideline 1 that make it clear that market concentration is contingent. That is to say, we look at it in order to draw conclusions about competitiveness or output or price. I read Sanjukta as saying that concentration is important independently of price and performance. But this is what DeLecker et al. Had to say. An increase in markups implies a decrease in output whenever demand is not perfectly inelastic, which is pretty much always. This is, by the way, the premise here is that labor is a variable cost, which is generally true. Lower output produced then implies lower demand for labor that results in both lower labor force participation and lower wages. Even if supply is perfectly elastic, real wages decrease with market power because the price of the output good has increased. Okay. In my mind, that's not a very controversial statement. There's lots of empirical evidence to support it, including more recent papers relating antitrust enforcement to high product output and in turn to higher labor force participation and wages. But then it raises this question: can we have a viable antitrust policy with respect to labor and not pay some attention to price and output in the product market? I mean, if we decide, one of the problems I tell you that I have with guideline number 1 is it makes it sound like we're pursuing concentration for its own sake, when in fact today it's pretty clear that concentration correlates very imperfectly with price and output. Frequently, it results in higher output and lower prices. It raises the possibility, assuming the Supreme Court would allow it, that a merger could be condemned even if it results in lower prices and higher output. But doing that is going to hurt labor. In fact, it could hurt labor a great deal if a bad antitrust policy, that is a policy that doesn't focus on product output, should reduce output in that market by, say, 10%, one would assume that there would also be a 10% reduction, more or less, in the demand for jobs in that market as well. And then depending on the amount of market power held vis-a-vis labor, that could do pretty serious harm to labor. So I think I'd like to give Aviv and Sanjukta a chance to respond to that first, and then anyone else on the panel.
Well, maybe I'll go first. So, Herb, if this was a deposition, I would ask you to repeat and simplify the question, because I think this is the prime example of a compounded question. There's so many layers on it, I could probably write a 50-page article to answer the various things. So let me just focus on one aspect, putting aside a couple of things. So first, I should comment one thing. You commented I assured you of something. Let me just remind you, what I've said are my views. I do not get to write the guidelines as I want to, so I can't assure you of anything. I can tell you what my views are, and you're happy to read them as they are. So I just need to comment on that. Look, at a high level, let me just talk about, I think, two sort of things that are coming up here, and there's many others. So first, just in terms of what we say in Guideline 11, what we say there, I think, is a pretty well accepted principle in antitrust, and that is that the labor market is a market, again, assuming we defined it, found, passed the hypothetical monopsonist test instead of a monopolist test, but passed the HMT and defined the market. And if there's harm in that market, we don't need to do balancing with other markets. That's not a new principle, okay? That exists in product markets as well, right? You could have a merger that's good in market A, product market A, and bad in product market B, okay? The statute said that a merger is illegal if it leads to a lessening of competition in any market, right? So that's what we're saying here. If it leads to a harm in the labor market, that could be a basis for a challenge. Now, it could be a situation, right? And this is where the agencies do have some discretion, where you could say there's just a tiny little bit of harm in the labor market and significant benefits in the product market, whether directly the product market is tied to labor or something else. It could be that the agency's discretion to not bring the case, okay? But the principle that we don't need to do the balancing, that's not a new principle. I believe was recently articulated by Judge Eastbrook in a decision, a no-poach decision, almost stating the language is almost identical to the one that's in the guidelines. So I don't think that's a controversial statement at all. What I read, kind of the quote that you refer to as saying, is that quite often, and in many cases, if one would use maybe the standard case when we think about monopsony, there is no trade-off at all. It could be that harm actually goes in the same direction. And maybe if I understood your question correctly, but maybe I got it, you might actually say, look, maybe we should even go further, and that is in cases where we're focused on the product market, and maybe somehow there's a balancing in the product market, not enough, we should then use the harm only in the labor market. I don't think that's inconsistent with what we said, in the sense that if there's harm in the labor market, you're right. In many cases, there is no balancing to do, because standard monopsony theory would say that there could be harm in both markets moving in the same direction. But even if there is a trade-off to do, we will, the labor market on its own could be a basis for challenging the merger. So let me just stop there.
Do you think there should be a categorical statement in the guidelines that no merger will be challenged based on a fact finding that it's going to result in lower product prices?
We can't have it that narrow for a variety of reasons. First, even if you employ, and I don't like to use this term because it's really ill-defined, but even if you want to sort of say, hey, we want to focus on the welfare of consumers, it's not just about prices. You could have harm that have nothing to do with prices. Okay. So we have to look much broader than price. So we cannot make a statement like what you just said, focusing narrowly on prices. Okay. It has to be about variety. It has to be choice. Again, even if you just want to look at consumers or workers, I'm going to use that synonymously, right? It's not just about the wages of workers. It's also about their terms of employment. It's about options. It's about a lot of other benefits that are included. That's one. The other thing, though, is, and this is where I think the lessening of competition helps. It's about outcomes, but not just about outcomes. One also has to look at the mechanism, right? So I think, I forget who gave examples of, it's a very different situation in a case where, let's say, if we look at, final prices, if they're coming because of a technological change or because of something else, right? So we'll have to look at the mechanism as to what's driving the effect, and it's not just about the outcome. So I don't know, and that's a convoluted way of sort of saying, well, I believe that the tools and measurement I talked before do in large part focus on outcomes. We have to take a somewhat broader view. I hope that answers your question.
Thank you. Okay, Sanjukta, did you have anything?
Yeah, so you're asking about the relationship between output and labor, and you're asking us whether we agree with one particular causal relationship that may exist between output and labor. I wouldn't disagree that that's one causal factor, what you're pointing out. I would dispute that this is the only causal relationship that should be considered between these two, very broad categories. And so to kind of, I think make this a little bit more specific, what are we talking about when we're talking about output? First of all, are we talking about one market, or are we talking about the whole economy? Big difference. If we're in antitrust usually talking about individual markets. And I don't think it's true that we should say that the goal is always more output in every market. Actually, that's inconsistent even with sort of basic economic theory the sort of standard mainstream economic theory. Sometimes it's efficient for resources to be reallocated from one market to another. So it cannot be the case that more output in every single market is always efficient. That's just not true. Internally not true. If we're talking about the whole economy, which is where this statement starts to become more plausible, that, okay, more output is good because we have full employment, we're moving toward full employment, we're moving toward higher wages, then this is certainly, I would agree, I think we can probably all agree we want economic growth at the level of the whole economy. But I wouldn't agree that this is the only causal pathway to focus first on output, to affect output through the sort of inflection point of price, and then let that affect labor. If we think about a very influential economist of the 20th century, John Maynard Keynes, he inverted this causal pathway, right? I mean, his whole point was that we should we should put people to work. We should look at wages. We should do work sharing through work spreading, through labor law was mentioned, through mechanisms like labor law. Part of the goal there was to spread work among as much of the workforce as possible, and therefore to increase demand, and therefore to affect economic growth that way. So it just, I mean, as I think Aviv said, this is a major topic that I don't think can be, and we're just scratching the surface, that I don't think we can just say this is uncontroversial, the implication for antitrust policy is obvious, and move on, right? I mean, this is a complicated topic, and I think if I may put a little bit finer point on it, for a moment, to take an extreme example, if there's a merger. And let's say that there is a large firm that acquires a medium-sized firm that's engaging in shoe production here in Michigan or something, and the firm that acquires that medium-sized shoe firm then outsources the shoe production to a lower wage country where those shoes are now produced in sweatshops under terrible conditions for very low wages. And we now end up with lower shoe prices and maybe more output. It is not at all straightforward to me that scenario is good for labor in any way that we're talking about it. So that doesn't resolve the questions, but I think that this is much more complicated than that statement would indicate.
Thank you. Ioana or Gus?
Yes, if I can just briefly add, I want to make 2 points. The first is to reinforce Aviv's point that ordinarily, we've talked a lot about a hypothetical case where a merger could, yield efficiency and price decreases and yet be bad for labor. And I just want to point out that under the most standard theory, that shouldn't be the case. Right? So like we're talking here about a hypothetical case that is not impossible and we can cook it to arise. But under standard theory, just want to remind everybody that if you have an oligopsony model, what you're going to have is that the merger increases the share of the merging parties, and that increases their markdown, or in other terms, they're going to lower wages because they have higher shares, and that under the standard model is going to also decrease the amount of labor that they employ, and that ultimately is going to yield lower output, which usually will increase prices. So I just want to make it clear that under our most basic, oligopsony theory, you shouldn't have this trade-off occur. Now, that's one thing that I think it's important just for context. But then we also have to remember, and this is been said in various forms by different people on the panel, but that merger enforcement is very much a fact-specific inquiry that looks into a specific market. And so, we are going to be looking, if there's a labor market concern, at competition for labor in that very specific case. And again, focusing everything on understanding the effects of the transaction on competition for labor in that particular relevant antitrust market that the agencies will have defined. And so I think in that sense, our concerns are cabined in a practical case to the relevant antitrust market that the agencies chose to define and looking at competition in that specific market.
I just would like to briefly respond because we hear this a lot, that in the classic case of monopsony, these two things go together. But the example I gave is not it was a hypothetical here. I'm happy to find actual examples. This is not a cooked up hypothetical. This happens all the time in the economy, actually. And so while the theory may say that this never happens, in reality, it happens. And when we have a conflict between theory and reality, I think that reality should win out. And this is maybe a good case for expanding the economic theories that we allow to be considered, which is completely consistent with the law and with the statutory framework.
Herb, if I can, of course, we're a bunch of academics. We all have something to say, but I'm going to, my response is a question or two. Aviv, a lot of the discussion is over how much the guidelines are actually changing what the agencies are going to do and potentially changing our understandings of antitrust law. And I'm hearing that they're not meant to be dramatic changes, which for me raises the question, why do we need a completely newly structured set of guidelines as opposed to small adjustments to the existing guidelines? And my concern to Sanjukta's point is I agree, these are really important issues. I don't think that they are antitrust issues. And I worry that they're going to get imported into and complexify an already deeply complicated and important area of the law when they are better left to being addressed by other policy mechanisms. So that's where I'm coming from on the labor monopsony discussion, in particular in the guidelines, but more generally in the guidelines. Herb, I don't know if you'll let me pose that as a question or not.
Why don't you restate it, Gus?
So the question is, if the guidelines aren't supposed to be making dramatic changes to antitrust law, such as I think Sanjukta is suggesting they could be interpreted as making, why do we have such dramatic changes to how the guidelines are being structured and presented? And is it possible that they could incorporate concerns such as Sanjukta is raising?
Well, I'll give you my own position, which I'm really not allowed to give since I'm only the moderator, but I share Aviv's concerns completely. What I don't share is confidence that it's really going to be different than what I see, which is that, guideline 1, which is the main guideline, the words market power, price, and output never appear, not a single time in that entire 3, 4, 5-page discussion. By contrast, the 2010 guidelines said, the unifying theme was increases in market power. And today we know that the link between concentration and price is not perfect. There are lots of instances in which markets become more concentrated but have lower equilibrium prices. And condemning mergers, that is making concentration the horse rather than the cart, is going to cause a lot of harm, and it's going to cause harm to both labor and consumers if they are interpreted that way. I would like for them to be interpreted as Aviv assures us they really are going to be interpreted, which means a focus on economic performance and not concentration for its own sake.
So,
Okay.
if I may jump in, just sorry.
Yes, sorry. Go ahead.
Patient, sort of, hearing a lot of stuff. Let me just sort of, Gus. I'm happy to this, broader discussion, but I don't think now is the place. We're focusing on guideline 11. Happy to have a separate panel talking about the goals and what we're doing. But let me just comment on guideline 1 and the relationship to market power and the unifying theme and so forth. Guideline 1, when it talks about the structural presumption, there is almost exactly the same language in 2010 that talks, the thresholds are different, okay, that we clearly change, but that talks about that crossing those thresholds leads to presumptions of illegality, okay? The one thing that's different, and as it's a drafting issue, is that in 2010, and I can pull out my copy of 2010 and read you exactly the language, is the following sentence, after saying that illegality, is saying that's a rebuttable, that can be rebutted using evidence of blah, blah, blah. I don't remember the exact language. Okay. We don't have that right now. That was the intent. Okay. I agree with you, Herb. I understand you saying, look, your promises, what you're saying here, especially when you're saying it's your own views, carry zero weight, as they should. Okay. Let's wait and see let's have this discussion after we have, the final guidelines. But the intent in guideline 1 was to change the threshold from 2010, but not go beyond that. Okay. And I
we
can go
need to
on
move
and on
to
about
questions because we are running out of time. I promised 15 minutes and we only have 6 minutes left. Do we have some questions, Andy?
Can I respond to Gus since I was specifically mentioned in that comment, or no?
Okay, go ahead.
I'll defer. But so it's two points. That one is, I actually agree with you that there are different tools for different purposes. Labor law isn't going to do the same thing as antitrust law, but that is conceptually a different point from whether the welfare of labor is one of the concerns of antitrust law, which I think is just beyond dispute. Earl Kintner says in the genesis of the Clayton Act that one of the primary concerns was the inability of labor unions to bargain with the increasingly powerful corporations and trusts, as they called them. So this should not be up for dispute that this is a concern. In terms of what tools are used, we can discuss that. We never get to that in these discussions because we're just on these preliminary questions, and it'll have to be a different panel. But those are two different things. Secondly, price and output don't appear in these guidelines, and they don't appear in the statute either. To bring those 2 points together, the antitrust agencies should concern themselves with maintaining rivalry, which is what the statutory mandate is, and then the labor agencies can handle other aspects of labor welfare. Then we can work that out from there.
Okay, we've got a couple of questions here. Let me read this one. How should antitrust law balance interests if mergers would lead to efficiencies, lower prices for consumers, and even better quality if it leads to increased concentration or lower labor costs? Is it really better for society if we decide labor protection is the goal of antitrust law rather than consumer welfare? Anybody want to take a shot? Gus, you're looking hungry.
Oh, I think I've already spoken to this.
Yeah.
My simple answer would be it's a hard empirical question. And I believe that the current guidelines and current antitrust law can incorporate this into its analysis and should.
So we talked about how the analysis is very much fact specific and should look at the state of competition in the labor market. And to that end, I just, following up on some of the comments also that Aviv just made, and with the issue of concentration, it's important to note that there is an economic literature on the impact of merger-induced concentration on wages that shows, for example, in the hospital mergers with Fraser and Schmidt, which was published in the American Economic Review, which was one of our top journals. There's another paper by Arnold, that mergers that greatly increase labor market concentration, meaning the shares of employers. So we're talking here really about competition for labor, that those mergers lower wages, right? So tend to lower wages. And so it's important, just again, this is for context. When we do an investigation, we're looking at the specific labor market, but it's important to know, just as a piece of context, that there are findings out there that inform us about what a rise in concentration is likely to do, especially specifically when it results from a merger.
Yeah, and let me just make one point here, that I take issue with some of the wording of the question that characterizes what we're doing as labor protection. Okay, this is not about labor protection. This is about protecting competition, and protecting competition in a market. The labor market is a market. Okay, it's not about labor protection. It's about protecting competition. That's the goal of antitrust rules. And I believe, Herb, you would agree, even though we might agree on some specific metrics. I think with the general goal, I don't believe that we have a disagreement.
I don't believe so either. Okay, we're just about out of time. Does anybody have another comment to make about this question? I don't even know if there's enough time to read this next question, but I will. Do you think the countervailing power theory, which often applies to suppliers, can also apply to labor markets? Sounds like a statement from Galbraith. Anybody want to comment on that one?
I'm not sure how that would apply except in a merger between unions. I may be misunderstanding the question, but presumably employers don't need countervailing power against workers. So I may just be misunderstanding.
Yeah, I'm not either. Okay, well, we are out of time. Thank you very much. I appreciate it. I think it's been a great panel and a lively panel. I appreciate that. And Carey, did you want to say anything, or are we done?
I think we can conclude.
Okay, very good. Thank you again, and I appreciate it. And this is Herb signing off.
Thank you very much, everybody.
Thanks, everybody.
Bye.
Thank you.
Thank you.